As of October 2017, he intended to begin law school in fall 2018 and expressed a desire to become an attorney. Hey, we heard about this guy, right? It seems like everybody really enjoyed Edward Thomas Kennedy and his lawsuit against all of his law schools and the Law School Admission Council, etc. And Betsy DeVos, don't forget Betsy DeVos down here. And remember, this was the one that was in memory of Eleanor Roosevelt. Thanks, guys. That was great. I'm really happy that you gave us your time and attention on that one. And so I have a bit of a reward for you. We have another one. And it's not just another sovereign citizen lawsuit. It is another Edward Thomas Kennedy sovereign citizen lawsuit. This time, he's getting kicked out of the United States Court of Federal Claims. This was on July 19th of this year. He is a pro se plaintiff. This is the on its own dismissal of the case. The court chose to dismiss this case without anyone needing to ask the court. The chief judge of the United States Court of Federal Claims, by the way, the Court of Federal Claims is a very special court. It is a federal court, but it is not a U.S. district court in the traditional sense. It only hears certain kinds of federal claims, usually monetary claims against the government and certain claims that are spelled out by law as needing to be filed through the Court of Federal Claims. So, he says, in this case, plaintiff Edward Thomas Kennedy, proceeding pro se, appears to allege that various federal and state actors kept him in constructive financial imprisonment after a state judge in Texas declined to vacate a judgment against him. Mr. Kennedy seeks $30 million in damages from each of several individuals and entities identified in his complaint, plus attorney's fees, costs, interest, and declaratory and injunctive relief. Mr. Kennedy has also filed an application to proceed in forma pauperis, which means as a poor person. As explained below, the court lacks jurisdiction to consider Kennedy's claims. Thus, without awaiting a response from defendant, the court grants Mr. Kennedy's application to proceed in forma pauperis and then dismisses his complaint. November 10th, 2003. Mr. Kennedy filed a document titled Petition in the Nature of a Petition to Vacate a Void Judgment and Collateral Attack, Oklahoma, Statute Title 12, Sections 1031, 1038, in the Tarrant County, Texas State District Court. The gravamen of Mr. Kennedy's allegations in that petition appears to be that Daniel Blumberg, a Texas attorney, allegedly committed felony fraud in connection with a prior federal court proceeding in the USDC for the Western District of OK in an effort to deprive Mr. Kennedy of money, property, and rights in contravention of Section 453 and Title 21 of the Oklahoma statutes. Although not entirely clear, Mr. Blumberg apparently had obtained a Tarrant County judgment for an unspecified amount against Mr. Kennedy following the proceedings in the Western District of Oklahoma. In his November 2010 petition, Mr. Kennedy alleged that Mr. Blumberg was guilty of fraud because he, quote, knew that the sum of defendant of Mr. Kennedy was different from and greater than a sum Mr. Kennedy could owe under any lawful theory. Quote, according to Mr. Kennedy, the purported fraud meant that the Tarrant County judgment was void and insufficient on its face, and therefore the Tarrant County court lacked jurisdiction to enter a judgment against him. In light of this allegation, Mr. Kennedy asked the Tarrant County court to vacate its earlier judgment and award him $25,000 as the standard damages for fraud plus costs. Mr. Kennedy served his petition on Mr. Blumberg as well as Kurt Ellison and Peter Bagley, both of whom were attorneys working with Mr. Blumberg at the time. Certificate of service, Mr. Kennedy avers in his complaint before this court that the presiding judicial officer, Judge Bonnie Sutterth, ignored his request. By the way, there is no such thing as the standard judgment for fraud. That doesn't exist. That same month, Mr. Kennedy filed a civil rights action against Mr. Blumberg, Mr. Bagley, and Mr. Ellison, and Mr. Kennard. Mr. Kennedy voluntarily dismissed the case March 10th. As of October 2017, he intended to begin law school in fall 2018 and expressed a desire to become an attorney. Hey, we heard about this guy, right? Mr. Kennedy acknowledged that filing lawsuits was a way to test his skills as a litigator. Wow. Mr. Kennedy has filed, since October 2017 alone, at least 21 federal lawsuits in Pennsylvania, New York, and elsewhere, 4 of which he has voluntarily dismissed. On June 12, 2018, Mr. Kennedy filed the instant suit, which shares similarities with the cases discussed above. He names several defendants in his complaint: Mr. Blumberg, Blumberg & Associates, Mr. Bagley, Blumberg & Bagley LLP, the current law firm, Judge Sutcliffe, the State Bar of Texas, the State of Texas, Mr. Kennard, Nelson & Kennard, Mr. Kennard's law firm, the State Bar of California, Patelco Credit Union, a Northern California-based credit union, Stephen Turner Mnuchin, Secretary of the Treasury, the United States Department of the Treasury, Federal Reserve Bank of New York, Thomas Marshall, General Counsel and Executive VP of the United States Postal Service, Megan Brennan, U.S. Postmaster General and Chief Executive Officer to the U.S. Postal Service, the United States Postal Service, and the United States federal government. He contends that, quote, each defendant is an agent of the other, and each has his place in the chain, of responsibility, and thus all defendants are vicariously liable for each instance of injury. At bottom, Mr. Kennedy alleges that the identified defendants, directly through an agent or in concert with one another, have kept him in constructive financial imprisonment. Mr. Kennedy refers to the identified defendants as kidnappers and bandits, apparently in connection with his description of financial imprisonment as a loss of liberty and his allegations that the identified defendants have refused to return stolen property. Mr. Kennedy vaguely alludes to personal property and trade secrets, but does not otherwise identify the property or trade secrets he alleges have been stolen, beyond stating generally that money is owed to him. He alleges Mr. Blumberg lied under oath and in documents and records in a county case in 2003, ignored his petition to vacate a void judgment. By doing so, they proceeded under color of law and stole funds from Mr. Kennedy by denying him funds that he asserts were rightfully his, resulting in a loss of financial liberty. Since, according to Mr. Kennedy, the Tarrant County Court lacked jurisdiction to enter a void judgment, Mr. Blumberg and Judge Sutcliffe breached their duty to prove jurisdiction when objection to jurisdiction is asserted. Boy, doesn't some of this sound like really familiar? The identified defendants breached their duty to allow Mr. Kennedy to proceed without injury, secured in his capacities, and to exercise his right to liberty. The identified defendants, particularly those who are attorneys, have breached their oaths of offices. Further, the business model of defendants is based on a foundation of deceptions, lies, and fraud. Mr. Blumberg, Mr. Bagley, Mr. Kennard, and Patelco Credit Union stole Mr. Kennedy's personal property and trade secrets. Mr. Kennedy has the right to demand and redeem lawful money from Patelco Credit Union and the Federal Reserve Bank of New York, and only recently became aware that he could do so. Thus, Patelco Credit Union has been unlawfully using the interest of his money since 1985, when he deposited his first paycheck. Hats off for a moment, guys. Just let's have a moment of silence for Mr. Kennedy's 1985 bank account. Mr. Kennedy demands from each identified defendant the greater of $1,000 each day for unlawful behaviors, or $5 million in general damages, the greater of which, or the greater of $5,000 for each failure to act, or $25 million in damages for the injury caused by defendant's absence of required actions. He also demands the return of the value of all bonds created in these matters in this case, permanent injunctions enjoining the identified defendants from interfering in any way with his lawful rights, and ordering the identified defendants to provide him with a lawful government and honor their fiduciary duty to him, and declaratory judgments that defendants have acted contrary to constitutional right, power, privilege, and in excess of statutory jurisdiction and authority, short of statutory right. Holy mackerel. So the judge is going to go over a bunch of stuff here for the next 7 pages. So bear with me. We're going to skim it. I don't want to skip it. I just want to skim it a little bit because it's going to be long. It's single page, single spaced. Pro se pleadings are held to a less stringent standard than formal pleadings, which is kind of how he's able to get away with this. Whether the court possesses jurisdiction to decide the merits of a case is a threshold matter. In determining whether subject matter jurisdiction exists, the court generally must accept as true all undisputed facts asserted in the plaintiff's complaint and draw all reasonable inferences in favor of the plaintiff. However, the court has no subject matter jurisdiction over frivolous claims. For example, there is no subject matter jurisdiction over claims that are so insubstantial, implausible, foreclosed by prior decisions, or otherwise completely devoid of merit as to not involve a federal controversy. The Tucker Act concerns the ability of the United States Court of Federal Claims to entertain suits against the United States. The U.S. is sovereign and is immune to suits, save from its consent to be sued. The waiver of immunity may not be inferred, must be unequivocally expressed. Further, when waiver legislation contains a statute of limitations, the limitations provision contains a condition on the waiver of sovereign immunity. What they're saying here is that the United States is a sovereign country, and even its own citizens can usually not sue the United States unless there is a law that allows it. So literally, the sovereign United States needs to consent to a lawsuit against it in some way. So you have to find a written law that pretty much literally says there shall be a civil claim in the event of yada, yada, yada. Under a liberal construction of Mr. Kennedy's pro se complaint, he is alleging claims for embezzlement, perjury, fraud, conspiracy, harassment, breach of fiduciary duty, negligence, violation of 12 U.S.C. 411, civil rights violations against federal, state, private individuals, and entities. Mr. Kennedy also appears to collaterally attack decisions issued by courts in Western District of Oklahoma, Tarrant County, Texas, without inquiring into whether Mr. Kennedy's claims are barred by claim or issue preclusion based on prior court decisions. It is clear that the Federal Court of Claims, or the Court of Federal Claims, lacks jurisdiction over his claims. Although the court has liberally construed the complaint in a light most favorable to him, the crux of the allegations contained are lodged against attorneys and state agencies. However, the Court of Federal Claims is the only proper defendant for the United States, not its officers nor any other individual. Because the United States itself is the only proper defendant in the Court of Federal Claims, this court lacks jurisdiction. To the extent that Mr. Kennedy asserts civil rights violations and commissions of various torts, his claims are outside the reach of this court's Tucker Act jurisdiction as well. They are not a federal district court, they are just a court of federal claims. So the Court of Federal Claims lacks jurisdiction over his criminal and statutory matters because he has not invoked any unequivocal, clear right to make these claims in this court. They lack jurisdiction over collateral attacks. His claims are time barred. It lacks authority to grant equitable relief. It's pretty much a monetary claim court only, and therefore the court declines to transfer his case. They do grant him the right to proceed in forma pauperis, which means he gets to avoid paying the $400 in fees he would normally pay. And then the court concludes that his claims are dismissed without prejudice. And if he is able to amend his complaint, I guess he's able to bring his claims again or something. But I think he should quit while he's ahead, except that it looks like he's been doing this for a very long time. And if you've been doing this for a very long time, you might not be learning from your mistakes. My mind continues to be totally blown by this guy who thinks that he's going to learn the federal court system by filing frivolous lawsuits. I'm sure he doesn't think they're frivolous, but they seem pretty damn frivolous to us, right?
I'm very intrigued by what trade secrets have allegedly been stolen.
Yeah.
Like, when I think about trade secrets, I think that they are similar to patents, that they are basically you protect that IP without revealing what it is in detail. But I think of it as, related to patents, or I think like KFC, that their 12 spice blend might be a trade secret or something.
Yeah, Coca-Cola is a trade secret. And if he gave his trade secret to somebody, like, that's his problem. The things trade secrets are protected from are from certain kinds of unauthorized acquisition or theft. Basically,
but, like, wouldn't you have to
corporate
use
espionage can prevent. Right, and you would have to be using the trade secret. He would have to know that you, like, it's not just like, oh, my trade secret.
Yeah, very interested what he thinks, what trade secrets he thinks he has.
Yep, it's a very strange situation.
I love this guy.
gift that keeps on giving. I'll give you that.
To be honest, like, just give them a law license. At least we will have content for years to cover them.
Oh, but he could do some real damage to the profession. That's my biggest concern.
I know, I wasn't 100%.
Oh, of course, I know.
Of course,
Of course, of course.
Can I ask one more question?
Of course.
Edward Thomas Kennedy.
Yeah.
So the court reviewed this sua sponte, so on its own, which makes sense for jurisdictional issues, where the court just looks at it and says, like, this doesn't belong here.
Right.
Can the court do that for the merits of the case as well, or is it just jurisdiction?
The court can do a lot of things on their own. Yes. The court needs to demonstrate good cause so that it survives an appeal. Courts don't like to do that stuff. In fact, if you're practicing attorney or you spend some time in court, you'll realize that courts, judges, people really, really like it when the parties agree to something, because then that's harder to appeal. So the judge will often not rule on something and require the parties to settle it, or require the parties to come up with the order jointly themselves, and then the court will enter the order as written by the parties, because that's much harder to overrule on appeal than the judge. So you're getting farther and farther away from not going to get overridden on appeal. When the judge is now issuing a sua sponte order on the merits of a case and throwing it out or something, that's probably the farthest from, the safe zone. Not saying it will necessarily get appealed and overturned, but it's more likely that that would be appealed and overturned than the sua sponte dismissal on jurisdictional issue. It's a spectrum. You're moving away from the acceptability on the spectrum then. All right, everyone, that is our show. Thank you for joining me. I am Leonard French, your favorite copyright attorney, and this has been another Lawful Masses Sunday show. This is a community-supported channel. Thank you very much to the Patreon supporters who are supporting this channel. We have other supporters as well, but our primary support system is through patreon.com/ljfrench. A big thank you to the following October supporters in the month of October. At the $50 level, Jonathon Doe, John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Sean McNamara, William Gonzalez, Michael Pearce, Grunkle T. Emeric, Terry Crisp, Richard Fournier, Michael Jones, Spirit Bear, and Jan Negrey. Thank you very much for your support. And thank you to the 200 plus $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl of the VOD. I believe we even have a new $500 plus supporter and a new $50 plus supporter coming in the month of November. So thank you. I think it's Justin Rogers is the $500 plus supporter. Thank you very much for your support there coming up in November. Really appreciate you all. Let's see if I have a little bit of dog video for you here. Thank you very much for joining me, and I'm going to go work on my electric trike. So love you all. Have a good one. Bye.